Good afternoon, everybody. Hoping everybody's having a good day, enjoying life, living life, loving life. It's been a while since I've been on and did a video. Had some other things going on and trying to work things out here and do some of my own projects and stuff. So just figured I better get on and do another video for everybody real quick. So please hang out. We're going to see if we can pull up some more viewers, and be sure to share. Everybody that's watching so far, please be sure to share. Because I got some simple information that will, I hope, help everybody overcome their very own enslavement. So please welcome everybody. Hey, how you doing, David? Billy? I see people coming on. Please, like I said, share the link. Katrina, how you doing? Tracy, how's everybody doing? Please be hitting that share button, because it's not going to be one of my usual videos where I got all my screens full of links. I got 1, 2, 3, 4, 5, 6, 7, 8. 10 links we're going to be looking at. 10 links only, and they're going to cut to the chase. And we're going to start with the one they're chasing. So please share, share, share. Shellen, greetings. Ooh, Shellen. You know, we just had our first snow yesterday. And so I want to give a shout out to Shellen. Thanks for joining me. One of my favorite little trades I got from my sister Shellen to help keep me warm in the wintertime. So when I tell you hit that share button and share everything, if you don't have a way to hit that PayPal link, you can share other things. I appreciate them all. So just one of those things, because we had some snow yesterday, we're changing outfits. Thanks, Shellen. Russell, welcome everybody. Please share, share, share. We're going to be talking about that dumb defendant, the idiot, the fucking fool. And if you guys know me, you know I've been telling you people I'm a fucking fool. I've been a fucking fool for a long time. I'm done being a fucking fool. I'm not the defendant. Recognize that. You are not the defendant. So, one for everybody to get started. Feel free to grab yours and take a hit too. It is free. Okay. So, let's look at defendant as they have it clarified in Cornell. I always like the LII Wex Cornell site. And you'll see on my tags up on the top, Cornell Law School is my first tag. So, just so you know, it's plain language. When we get into the text documents issued from the government, plain language, but they have the excess material and stuff, and the Cornell site cuts to the chase. So that's what we're doing here. We're going to cut to the chase on defendant. Defendant, in a civil matter, the party sued by the plaintiff. In a criminal matter, the party who is prosecuted. Okay, first thing I want to note is every time they bring you into a court case, they are bringing a prosecutor on behalf of a plaintiff. Right? So they're bringing a criminal matter in regards to a civil plaintiff. Okay? Make sure you comprehend this very simply. It's one sentence. In a civil matter, the party sued by the plaintiff. In a criminal matter, the party who is prosecuted. So when they name a defendant and they bring you into court, by a prosecutor and name a defendant. They are mixing jurisdictions right from the start by using the term defendant as it is defined, people. As it is defined. The term defendant itself shows clear and in, on, and for the record facts, prima facie, that when they bring a document in those civil courts and name a prosecutor and a plaintiff, they are bringing both a civil and a criminal matter. They are mixing subject matter. Okay? First, recognize this. There are two jurisdictions there. Now, personal jurisdiction. Personal jurisdiction refers to the power that a court has to make a decision regarding the party being sued in a case. Now we're going to go through this personal jurisdiction and I'm going to show you. We go up here to this top right corner. We'll click on those three dots. We go down here to find. We go up here when we put when we get to pros. Pros. Not prosecution. This is a different term, people. This is a different word. So before we get to prosecution, we get to pros, and it shows zero evidence. So this code is got no pros in it. It's posing nothing. So we're going to continue on and we're going to watch, because there is no other discussion in personal jurisdiction other than regarding the party being sued in a case. It doesn't say anything about prosecution, okay? That's the threat. That's the threat, people. They're going to prosecute. That's a threat in a civil jurisdiction where it's contract venue and it's supposed to be arbitration. So to bring somebody in under a contract without proving that there is breach first through a investigation, they cannot just bring somebody in under threats, duress, and coercion to gain personal jurisdiction to then sue. You get it? This is two sentences, people. Two sentences. The only sentence in Cornell describing defendant, and the first sentence of personal jurisdiction. Relates nothing to prosecution, and nowhere in this does it discuss prosecution. Contrast, here it talks about subject matter jurisdiction, which cannot be waived. And this is what I'm talking about. Cannot be waived. Because they first have to have personal jurisdiction to decide the venue. They can't pick a venue and then decide the personal jurisdiction. Can't be done, folks. They cannot determine the subject matter jurisdiction based on a defendant who is in fact being claimed in two different jurisdictions. It's impossible. This is plain writing. They're saying in a civil matter, the party sued by the plaintiff. In a criminal matter, the party who is prosecuted. If there's a party being sued by a plaintiff, then it's not a prosecution. It's a lawsuit. It's a civil procedure. So why are they bringing in a prosecutor instead of an arbitrator? It's a very distinct difference. Go to your brother in private first. They bring in a prosecutor and take you to the public forum. So let's finish on. Before a court before a court can exercise power over a party, the U.S. Constitution requires that the party has a certain minimum contacts with the forum in which the court sits. Okay. The forum in which every state court sits is the forum of the U.S. courts. They do not have the power over any persons unless the United States has qualified that person at a customs border check upon importation or coming into the entry into the country. So if we're born here, should the United States have a record of entry or import? No. Yet they issue a birth registration, which is an important document of matters of national security. It is an import document. They imported data elements into their record. The importer of the record is liable, guaranteed. And they are liable for that very power of personal jurisdiction before any state can even assert it, because the state has to check with the United States through diplomatic channels of notice to see if that person is in fact incorporated or not incorporated and has been recorded as such. There has to be a record of that person. So, again, before a court can exercise power over a party, the U.S. Constitution requires that party has a certain minimum contacts with the forum in which the court sits. That's the birth registration, wherein we may make an agreement with an official of the state for a birth registration to assist us in assigning a social security number to a newborn child in the state. So it's the state assisting the United States in assigning a social security number. In this case, it shows this International Shoe versus Washington, and that explains how before a court can exercise the power, and brings in the Constitution. The Constitution is the import document. It is the import document. It has to comply with the Constitution of the Universal Postal Union under the Treaty of Berne and through the North American Free Trade Agreement and the Uniform Customs Codes. Not the Uniform Commercial Codes, it's a different UCC. So, we go on, it says, so if the plaintiff sues a defendant sues a defendant, that defendant can object to the suit by arguing that the court does not have personal jurisdiction over the defendant. Can object to the suit. Again, it's not saying anything about prosecution. So these people are threatening prosecution and say, you got to show up in court. Well, you got to explain whether it's a lawsuit or a prosecution of a crime first, because you've named a defendant and haven't disclaimed which it is. Period. And it says, by arguing that the court does not have personal jurisdiction over the defendant. I'm not going to argue. I'm going to place the point, in fact, that in this definition, it says it's being prosecuted and there's a plaintiff suing you. So I want to know if it's a civil suit or a criminal matter. This is the question they won't answer. They will not answer that. You have to show up first to grant them jurisdiction, personal jurisdiction over the defendant. And I'll show you here. It says waiving personal jurisdiction. Personal jurisdiction can generally be waived. Contrast this with subject matter jurisdiction, which cannot be waived because it is attained after personal jurisdiction. They have to get personal jurisdiction first. So if the party being sued appears in a court without objecting to the court's lack of personal jurisdiction over it, then the court will assume that the defendant is waiving any challenge to personal jurisdiction, and this is at Federal Rules of Civil Procedure 12b2 that they're talking about. Failure to state a claim upon which relief can be granted. We're going to destroy that. They have failed to bring a proper claim because they brought a suit and a prosecution as subject matter jurisdiction under threats and duress and coercion to bring the party into the court, thereby supposedly obtaining a voluntary appearance. Watch this. Obtaining personal jurisdiction means that they don't have it yet. They can't have personal jurisdiction over defendant when they're claiming a civil matter and a prosecution. That's dual jurisdictions. They have to clarify the jurisdiction first. If they can't clarify the jurisdiction first, and they're depending upon somebody showing up in court to give them personal jurisdiction so then they can clarify the capacity of the subject matter, then that's a false process. Typically, for a court to have personal jurisdiction over a defendant, the plaintiff needs to serve the defendant in the state. That's territorial jurisdiction. This is the constitutional question that Malika and I keep bringing up under Article 1, Section 8, Article 1, Section 8, Clauses 1, where Congress shall lay and collect taxes and duties and imposts. Post. Get it? They are the extension of the post office. Article 3, the commercial activity, judicially regulated by the post office. First and foremost, under the Military Board of Commissions and the Postal Board of Commissions. Postal Regulatory Commission. And then Article 14 is the person that has to be commissioned through an office or as an agent. You have to have a broker's license as an agent or an oath as an official. So then we turn around with 17. Section 17 of that same section, or Article Section 8 and Clause 17, Clause 17, is the needful places and buildings. And every last one of them is in fact a post. Some are known as post offices, but they are all, in fact, inland marine stations staffed by postal service workers or other civil service volunteers under contract. Pure and simple. That is the 18 U.S.C. Section 7 special maritime and territorial jurisdiction. They have to have personal jurisdiction first as an officer of the military or a civil servant, volunteering their services under a contract for a per diem, in which the court sits. The court sits in a state that ceded its jurisdiction to the United States for that very admiralty jurisdiction for landlocked states. It is an insurance for those needful buildings in landlocked states wherein they are inland marine insurances, extensions of the marine insurances of admiralty. In those states, the residents are duped into applying for a driver's license, Social Security, insurance, and transferring their property to titling of the state for ownership, and they are in fact insuring their own property when they are in fact already insured, not only through the SS5, which is not required, but as a presumption of the record that is misconstrued and describes that man as a resident or official. Not required. That birth registration is in fact false. You did not certify it with a handwritten statement qualifying the donation of your name to be enumerated in that system. Mother did that. That does not qualify as a proper donation. Period. And the defendant needs to voluntarily appear in court. And the defendant, so it's not just the plaintiff needs to serve the defendant in the state in which the court sits. It says it needs to do so, and the defendant needs to voluntarily appear in court. This is that 22 CFR 93.1 and 93.2 that I keep discussing. The plaintiff needs to serve the defendant, the person, not the resident operating the transmitting utility for the person. The defendant is the record. The name and number identify the record, not the man. This is why the defendant needs to voluntarily appear in court. Will never happen unless you bring that defendant in with you as a man. We've seen it all the time. Kate of Gaia posted her video of Keith walking into the court, Kate, as her man in a transgender form, as a male, walked into the court with a birth certificate and handed it over for that such appearance, clarifying the distinction between the defendant and that personal jurisdiction. That's why they have a problem with that. That is very accurate position that is posed in handing over the birth certificate. It's your property. You gave it to the beneficiary, or the beneficiary record to the beneficial end user, and as the benefactor of that use, I'm giving it back to the United States. I got it from the state. I'm giving it back to the state and giving them an assignment to hand it back to the United States and transfer all the interest back to the United States. That's what that process is all about, because they're failing to name the person and the proper record. Period. So let's get on to the next one. Oh, well, let's finish up. Federal Rules of Civil Procedure Rule 4K describe whether a state's courts would have the authority to adjudicate. That's a judicial thing. Adjudicate. Judicial. A claim as it relates to personal jurisdiction. They can't. Again, the Postal Regulatory Commission and the Postal Rate Commission under the Board of Military Commissions. All contracts go through those jurisdictions for personal jurisdiction. It must be recorded. Absolutely. And if it is through that birth registration and it's false, these are the people that will take care of it. Here locally. You want to go to the international level, it goes to the Joint Chiefs of Staff, the Director General of the International Bureau, the President of the UN, the Swiss Confederation, the Federal Chancellor. Period. I don't have to do anything, Brother David. I don't have to issue any documents. I've got so much information, I'm destroying them with all of their codes. That's all it takes. I'm just pointing out that their defendant, it needs to be clarified in every case. And it hasn't been clarified according to the record I've got. It says a summary. So it hasn't been finalized. So now I get to shove that record down their throat. That's all I'm going to do is I'm going to hand it all back to them. And I've got 6 years of going through and line item vetoing it and overriding it with all the corrections. And I'm going to shove it back down their throat. So let's look at general appearance. There's one of my favorite terms, general appearance. A general appearance is made when a party first comes into court. A general appearance is made. It's not there. It's not there. There is no appearance. There is no requirement for appearance. It's voluntary. There's no requirement for appearance, people. Quit letting them try to put you in fear. Destroy them with their simple words and their babble. First comes into court. Not when he's pulled over alongside the road and appears in the case. A civil or criminal proceeding, not both. That's the matter that's got to be cleared up before you come in. Is this a civil matter or a criminal matter? One question. they have to answer it. If they say it's civil, again, is my appearance required in the court? If they tell you yes, they have just lied. Ask them if your appearance is required in the court. If they say yes, then ask them, oh, so it is a fact in, on, and for the record that you, what's and what, so-and-so's name, not the corporation, but you, Michelle Wagner, have personal jurisdiction. You have personal jurisdiction without an appearance in court yet? Ask them through the mail, do you, Michelle Wagner, have personal jurisdiction? If they say yes, they have just lied, and it is proof in, on, and for the record, and the defendant needs to voluntarily appear in court to obtain personal jurisdiction. They have to appear in the forum, in the venue, in the public. The party may come for any reason that recognizes the authority of the court. We're going to go and we're going to recognize the authority of the court only as concurrent jurisdiction for failure to cede, and that is because we are coming in to let them know, giving our notice, that there is no personal jurisdiction. It is a requirement of the United States that you contact them. Therefore, I'm handing this document back to you and letting you know I am contacting the United States and handing them a copy of your assertion of personal jurisdiction without proving it. A lie in, on, and for their record. Period. Some states follow common law and do not consider a general appearance made when a party comes into court purely to challenge the court's jurisdiction over the defendant. Again, I am not challenging nothing. You do not have it, and there is proof in, on, and for the record in your own codes that you do not have it. Because nobody has appeared voluntarily in that forum yet for that case. That's why those 11 cases can't be brought up. No one appeared. The court's personal jurisdiction over the defendant. This is instead known as special appearance. Special appearance is a tool. It's a tool, not a weapon. Defendants can use to challenge the court's jurisdiction over them. It's not over you. And you are not the defendant. Again, realize the language is a tool defendants can use. The defendant can't use it. You are using it to dismiss, to dispel the defendant by taking away the terms, the conditions that were placed at the end and the beginning of the root term, fend. You are the fender. Oops, did you get in an accident? You have a little fender bender? So let's talk about the forum nonconvenience. We're talking about the forum, and of course this is nonconvenience Latin. It means the forum is not convenient because there's a concurrent jurisdiction going on. United States, who would be better qualified for personal jurisdiction determinations because they're the ones that have the assistance of the state in assigning the number that enumerated the name. Period. A court's discretionary power. That's the only power they have. And they must first discern the defendant. First. In order to qualify it as a defendant, they have to get the personal jurisdiction. If they can't get the personal jurisdiction, then they can't even communicate with the fucking United States to determine whether you're suable in the court. This is the impossibility of them having your name on any record and saying that it applies to you. They got the information in error by somebody else's accident. They had a little fender bender with mom, not you. They bent the fending. They added conditions onto it that changed the term from the immediate delivery that mom had to an entry into transportation that would last repeatedly over a course of time, subjecting you to public liability, and that is the accident. Forum nonconvenience is a discretionary power that allows courts to dismiss a case where another court or forum is much better suited to hear the case. Form AO430, Administrative Offices of the United States, Case Information Record. Case Information Sheet, When you look up that form, it tells you the defendant is the creditor. So if they put that name down as the defendant and they are prosecuting, and they have not checked with the main creditor in the obligations and other securities of the United States, and that is the United States, they have made a false claim against the United States, and they are warring against a person of the United States, and this is against the Trading with the Enemy Act. Period. It is that simple, because it has already been set forth in res judicata, in, on, and for the record, because they have not clarified it. It is all a presumption, and no one has appeared voluntarily in that court if they have been threatened under duress and coercion of prosecution, meaning they are appearing in a civil venue for a criminal prosecution, and therefore the court doesn't even have subject matter jurisdiction, and have threatened you under threats, duress, and coercion of appearance, that if you don't, they will kidnap you. That, people, is extortion. You ask any legal professor if that is not extortion. And I'm not taking one day of college. Not one. I've not spent one dime on that education beyond high school. Except for the work experience of getting fucked. But again, it was my own fault. See, the greatest history lessons I've had my entire life, I took upon freely myself over the last 6 years. And that's why I'm out, folks. I'm not done here. I'm done with them. And I'm out of that system, whether they have it on their record or not. Because the truth is blatant. And one term will destroy every document they ever put on that record claiming that I was supposedly a defendant. Or you. Any of it. None of it's true. Not one bit. So let's finish up real quick. Because now we're going to get to the juicy. Forum shopping. See, that's what they're doing when they're trying to threaten you. Like I said, there's two forums before them, a prosecution of criminal forum or a lawsuit in a civil forum. And they need one of those forums in order to prosecute, and they want you to step up and give them personal jurisdiction so they can shop for the best forum. And in their shopping, they may not finish their shopping in one forum and then switch forums and decide to go shopping in another forum because they have that personal jurisdiction. And it's still just a presumption. Because it's still voluntary. See, because there's no contract. Otherwise, it would be stated as a contract and not voluntary. And voluntary is synonymous with arbitration. So when we fill out that birth registration by mom, it starts a process that continuously exposes one to public liability, even when you're a little baby. And then when you turn 18 and you fill out your own application, the SS5 application, and then don't correct it, or don't fill it out in the correct manner, or dismiss it by submitting a different documentation to rebut the birth registration. Whatever it is, that application becomes abandoned in that system because nobody's actually, in fact, stepped up as trustee to collapse the account, which is what is, in fact, supposed to happen, because that birth registration is, in fact, false because mom nor you never certified it. So it is a bastard child floating around in the seas of commerce, causing all kinds of fender benders. It is literally an accident waiting to happen, and that is why it is required to have a second or third insurance. Because, see, the abandonment or the birth registration is the initial marine insurance through the Department of Defense. And then in a secondary agreement in an inland contract, the second insurance is the Social Security Administration. And then as a third contract, once the child becomes of age and gets a state ID, fills out that SS5 and gets a driver's license or that state ID, that is a third insurance. Again, it is just Incoterms passing on the insurance to the next buyer-seller, and you are not a buyer-seller. That, in fact, is what that SS5 application is it's an investment application to be a buyer or seller, and you never qualified as a buyer or seller through licensing in the proper manner. It has all been presumed. You have never taken an oath of office or gone to college to acquire the prerequisite credits to be licensed. How's that for credits, folks? Let me ask you. How many credits do you think I need now? Huh? Can that be enumerated? Can you put a number on that? Or is that priceless? See, when we abandon things, it's ourselves that we're abandoning. In 1031 exchanges, look up 26 U.S.C. 1031. Exchange of real property held for productive use or investment. Rutrow. Special rules for foreign real property. Real property located in the United States and real property located outside the United States are not property of like kind. Rutrow. In exchange, i.e. sale and reinvestment of the proceeds therefrom. See, what the United States did is they sold the state an account for them to reinvest the proceeds therefrom. So the state has to provide proceeds from that account as a reinvestment in the original account. The only way the state can do that is through you, suckers. You're the ones donating through your employment, through the SSA contributions and the federal Income Contributions Act. Are you a federal employee? Are you an official of the state? Are you an agent? Did you take the proper college courses to become credited by the accreditors of false languages and babble? A business or investment property. So we see a conversion of real property to business or investment property in 1031 exchanges, listed under 26 U.S.C. 1031, which are have to be of like kind. For like kind business or investment property, which allows a seller to defer payment on capital gains taxes without being said to the buyer. Where do you think that seller is deferring the capital gains taxes to? To the buyer who's supposedly investing for those capital gains. Suckers. And guess what they need? They need that voluntary appearance in court. And so not only do they need service of process and the voluntary appearance, but guess what? In that voluntary appearance, like I said, it's a construction of a contract to produce a certificate under construction of a trust. And so they have to produce a certificate. It means they need a signature. So here we go. Security power, and this is from the U.S. Securities and Exchange Commissions in regards to those 1031 exchanges, folks. Security. A security power, often called a stock power or bond power, is a legal document separate from a security certificate. Those documents they're passing around in the court are legal documents, and they need your signature on them so they can have the power to issue the stocks and bonds in certificate form that investors can use to assign or transfer or assign ownership to another person. That's the simple process. Securities powers typically are used either as a matter of convenience when an owner cannot sign the actual certificate, which is what the courts are doing. They're getting the legal documents through a transfer of power so they can sign it. For safety, is that insurance? Such as sending unsigned certificates in one envelope and signed powers in another. Wait a minute. Isn't that certificate supposed to be attached to the document making the assignment of the powers? Would that be an accident? Would that be the requirement for the insurance? Would that be proof that these certificates are not, in fact, valid? Physically, a securities in one end or power looks like the back side of a security certificate. Get your certificate of title out, folks, and look at the agreement on the back of that motor vehicle certificate of title, and it can be completed in the same manner. Market professionals typically attach a customer's signed powers to the related unsigned certificates for processing purposes. That is the simulated legal process, and that is just blatant abuse. Blatant abuse, folks. The next one is, what is a fidelity bond? A fidelity bond is a form of business insurance that offers an employer protection against losses that are caused by its employees' fraudulent or dishonest actions. You guys remember that document I read to you about the post offices being inland marine stations, and that they are staffed with United States Postal Service workers or Postal Service employees? See, the employee is the United States Postal Service workers. The employer is the postal system, not the United States Post Office. The International Forum, Universal Postal Union. It is a labor union. And it has stations in every country on this planet. That's the employer through the Swiss franc, the postal unit. These people are conducting that in fraud. And that's where the fidelity bond lays. See, the postal system has a postal realty investment trust, real estate investment trust. We're talking about real estate investments, right? We're talking about real exchanges. We're talking about the exchange that already occurred between the Postal Service and the Postal Union. Yeah. See, that's where all of these states and the United States has a fidelity bond. It already exists. Why are you required to have insurance then, if the fidelity bond is already there? They have to prove you're an employee under that fidelity bond. They can't. What is a banker's blanket bond? A banker's blanket bond is a fidelity bond purchased from an insurance broker. You suppose the United States is the inland insurance broker through the United States Post Office? As a second insurer, a reinsurer that then turns around and gets the states in agreement to assign a number to a newborn child as a third insurer, and somehow you grow up to be the fourth insurer? And it says that protects a bank against losses from various criminal acts carried out by employees. Get this, folks. Yeah, you guys ever seen 12 U.S.C. 3201? Oh, maybe it's not that one. Let's look it up here. $31.02. Excuse me. Now, mind you, this is a banker's blanket bond, is a fidelity bond purchased from an insurance broker that protects a bank against losses from various criminal acts carried out by its employees or by employees. Did you guys know that the establishment of federal branches and agencies was by a foreign bank? It's plain writing, folks. Establishment of federal branches and agencies by foreign bank. So the federal branches and agencies being established by a foreign bank is in fact a trust company that operates under a foreign bank. See, the United States is a trust company operating as a foreign bank with a fidelity bond, putting forth employees of the guy that holds the fidelity bond, the postal union. Every last one of them's already bonded, and they're all subject per license. You see them with those license plates on the cars, and they're subject to the ones that don't have to carry license plates. Why don't they have to carry license plates? Because they're the primary contractor. They are the universal contract powers of the world. If you want to assert your power, that's who you'd be going with. And again, it's just a matter of pointing out where those bonds lie. Period. So I'm going to go and I'm going to open up a Zoom here in a little bit for those that want to discuss this. But I'm going to wait for the video to post so I can go through everybody's comments so I can post or jot down some information that I can bring to the Zoom link. But this is it for the video. But like I said, I'm going to come back with a Zoom. It's 4:30 now. The video's been just under an hour long. So I'm done for now. And like I said, I'm coming back with a Zoom with some more information. Those that want to come back and join me in the Zoom, watch for my Zoom link in a little bit. In the meantime, thanks for joining me. Share the video. Invite other people that come to the Zoom here in a little bit. See you then. Remember, folks, I love you. If it wasn't for you guys, I wouldn't be doing this. Have a good day.